those news and talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office here anytime at 1-800-DeWitt-Law or interact with the show by sending an email to ask@dewittlaw.com. Get those questions in so we can get to them. Or you can also call and leave a voicemail at 407-53-MOSES. My name is Jay Edwards, and every Sunday morning at 10 a.m., you'll learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions and discuss the latest legal issues affecting the citizens of Central Florida. I got to tell you, Mo, that little cold front that we got midweek, man, can we go back to that completely?
That was pretty nice.
That was really nice. It just, I swear, I think everybody on the roads and just in general, people were just in a better mood when the temperature
makes you a little happier when it first happened.
Yes.
Live in freezing cold conditions for long enough, you get real grumpy.
Yeah. No shoveling snow at all. Not for me, not ever. All right. So if you do have a question, and we've got a nice stack of them that we're going to get to today again, send in your questions if you'd like some legal advice to ask@DeWitt, DEWITT law.com. Ask@DeWittLaw.com. All right, Mo, let's get to our first question today. Contemplating a divorce. I want to leave the home. What do I need to do to ensure that I am not waiving my rights to my home or my kids?
So that's a pretty common misconception, probably one of the most common misconceptions that we get kind of on a daily basis. In Florida, there's no such thing as abandonment. So by leaving the home, you're not abandoning the rights to the property. You're not abandoning the rights to your children. Really, the courts and the judges want you to be safe. They want you and the kids to be safe. So, if you're getting a divorce, things may be contentious at home. They may be hostile at home. So if you're able to financially afford it, getting your own separate place and moving out, there's nothing wrong with that. And again, you're not waiving any rights to the marital home. I've had cases where people move out of the home and then ultimately as part of the divorce, they get the home later on. So there's no real concerns there. What you do want to be worried about though is, with your kids, you're not waiving any rights to them either, but you do have to work out some sort of time sharing arrangement going forward. So, if the kids are going to be staying in the marital home, if they're going to be going with you, these are all conversations that you have to have with your spouse or soon to be ex-spouse. Obviously, if you're going through a divorce, those conversations may or may not be possible. Mm-hmm. So then you want to kind of plan things out and plan out, the divorce process and time them appropriately. Because if you're going to move out and they're going to refuse to to allow you time sharing, maybe you need to get time sharing ordered by the court, maybe even before you move out. Hopefully that's not necessary. Hopefully you can kind of move out and you guys can agree on some sort of temporary time sharing schedule. It would just be temporary. You still have the divorce to deal with. You still have to go through the divorce process. So anything that you agree to now, it does not automatically become permanent. Things can change. Schedules may or may not work. So this can all be adjusted down the road. But those are the things you want to be looking at if you're planning on moving out. Now, obviously, there's going to be a lot of things involved with that. If you're moving out, there may be some things that you want that your spouse wants. My general rule of thumb is if you're going to be leaving the home, only thing that you really need to be worried about is anything that is, irreplaceable, right? So items can always be replaced, financially. Mm-hmm. If you want the bedspread or the bed set and he wants the bedroom set, you guys can work that out in a financial aspect. But if there are things like family photos, family heirlooms, you may want to move those into a safe place, put those in a safe in a secure location. You can let the other side know where they are. Maybe you don't give them the key depending on the situation, but you want to just make sure that those don't get destroyed because, if they're those types of items, you just can't replace.
Right.
With money,
yeah.
Right. So, otherwise, whatever you're going to take or not take, you guys just have to kind of work out between the two of you, and then everything will be handled as part of the divorce going forward.
What, going back to with the kids and figuring out time sharing, what if you do spring it on your spouse that I'm done, I'm going to go stay at my buddy Mike's house, or I'm going to stay at my family's house. And I'll take the kids every other day or something. And your spouse says over my dead body, if you're leaving me, you're not seeing the kids. And I'm sure that happens.
It does. I mean, anger makes people say a lot of things. But in that case, then you probably want to go meet with an attorney and basically talk to them about the situation. You may still, depending on the situation, it may still be best for you to leave the home,
Mm.
get into a safe place. Then you want to talk to an attorney and get something filed as quickly as possible to go ahead and establish time sharing going forward. And you really want to start that. If you think that's going to be an issue, you may even want to start that before you have that conversation, because the courts can be slow. Depending what county you're in, you may have to go to mediation before you're allowed to go see the judge, unless it's an emergency. So there are some headaches that can arise there. So the sooner you start it, the better, basically.
You know how if, say, you let somebody move into your house and after like 30 days or something, it's hard to get them out because now they kind of live there.
Yep.
And I know I'm probably not getting that exactly right. Does the same hold true in the reverse, to where if somebody does say, we're leaving the house, we'll try and see if we can work it out, but we're going to separate for now. And say she moves out and she's out of the house for 5 months and doesn't have as much to do with the kids and hasn't been in the house or necessarily paying the bills. Does that go back to waiving her rights with the home or the kids? Is there a time frame that, okay, get it together?
Not typically, because
Okay.
it's still a marital home, right?
Okay.
You still both equally own the home, jointly own the home. One spouse has as much right to the home as the other spouse, frankly. So, yeah, one party could change the locks to make it a little more difficult for you to get back in. But from a legal standpoint, you both have equal rights to that home. And I have had cases before where one party moves out, becomes too expensive, and they begrudgingly move back in and kind of live on their separate sides of the home.
Right.
Not real pleasant, obviously. But during a divorce, things can financially be very tough sometimes. So
Right.
yeah, there you don't really waive anything.
Okay.
Because you're still legally married. It's still the marital residence. It's still marital property. Even if, we get the case a lot too where, oh, but he bought the home before we were married, so he thinks we can kick me out. Well, no, can't do that. Not allowed to do that. And as part of any divorce, typically there's what we call an administrative order that goes into place where there's certain rules that everybody has to follow as part of the divorce. It's a court order that's automatically entered basically in every single divorce case.
Mhm.
And so overall, a lot of what that says is that the parties must maintain the status quo. So things like trying to kick the spouse out is not going to be allowed. Things like if one party's kind of financially supporting the household or the family, removing that financial support is typically not going to be allowed.
I'll cut you off. I'll show you. You can't.
Right.
Do that.
Yeah. I'm going to starve you out on this divorce, and you're
Okay.
going to agree to what I say, or you're not going to get any money. That's not allowed. Changing the kids' schools. There's a multitude of things
Sure.
there. But those things are typically not going to be permitted because, for obvious reasons, they don't want one party to have an advantage during the divorce and the other party to, kind of have to succumb and to the other side because one party controls the finances or controls the home or whatever it may be. So, again, I think the biggest thing the courts look at is, what's in these parties' best interest, and they certainly want everybody to be safe. So they want to make sure that both parties are safe. And, they deal with domestic violence situations all the time. And I always tell people, if you're going through a divorce, if you're going through a difficult time, the last thing you ever want to do is put yourself in a situation where you could become the victim of domestic violence or be accused of committing domestic violence.
Right. Yeah.
Because we see that a lot too, unfortunately. So, if that's where it's best just to remove yourself from the home as much as possible. If you do have to go to the home, if you can have a witness or cameras, obviously disclose others' cameras, but those types of things, that's really going to be your best bet because when domestic violence accusations come into play, things escalate quickly.
That's a different ball game.
Different ball game. It can be a headache. In those cases, they can remove you from the home. They can remove one party from the home.
Right.
It can affect your job. If you have security clearance, it can affect that. It can really be quite the headache to deal with, frankly.
Outside of domestic violence or something like that, is there a common mistake that men or women make when either initially going through the divorce process or during the divorce process? Just a common mistake that if maybe this is something you're just starting to contemplate, something that you're just going through, that you can tell people, man, listen, I can't tell you how many times he or she did this, and that ruined things for them.
Well, I think the biggest thing is just kind of understand the mindset that you need to be in. So, obviously people are angry going through a divorce. A
Mhm.
lot of times they come into it with a scorched earth mentality, right? I'm going to take you for everything you're worth. I mean, we see this in movies
Sure,
and
yeah.
TVs and in real life all the time. But, when the court's looking at a divorce, they're really looking at this as a business transaction with the exception of the kids. So they're really just saying, all right, we're dividing up the assets. You get this, you get that. And then if we have to deal with the kids, that's a little different. But they don't care what happened in your marriage. They don't care, who had an affair with who or who did some awful thing or didn't buy you a birthday present or whatever it may be.
Doesn't come down to that.
The judge does not care.
Right.
What they care about is basically valuing and distributing the assets. If there's alimony, obviously they're going to deal with that, and then doing what's in the best interest of the children.
Mm-hmm.
So, sometimes people ask me in a consult, they go, well, how many divorces do you win? I go, you can't answer that question because really nobody's winning in a divorce.
Right.
We have cases certainly where people get what they want or some of what they want. Rarely does anyone in a divorce get everything they want, frankly. Every once in a while it happens. But there's just no winning, right? You're starting with, a bucket of assets, and then you're going to be leaving with half of those assets. You're starting with kids that you see every day. Now you're going to see them half that time. So, everybody has their preference on how that's treated, but there really is no winning in a divorce. I think it's a loaded question.
Right.
And every once in a while they'll say, oh, so-and-so attorney down the road says he wins 97% of cases. I go, what does that mean? What does that even mean?
Right.
That you got 97% of the people actually divorced? I mean, yeah, getting divorced isn't the hard part.
Sure.
It's dealing with all the other aspects of the divorce.
Yeah, but I mean, you leave with half of what you came in, like you said, and then half the time with your
Right.
kids. If you consider that a win, then okay. But
Right. It's really about kind of creating a new life that's going to work for everybody. Right. So
everybody leave happy.
Right.
Happy, not necessarily win, I guess, right?
Well, leave in a sense that they can go on and start a new life and they have the ability to move on with their life and they don't have to deal with the divorce anymore. They're financially stable enough to get back on their feet and do whatever they need to do. And that you have a schedule that works for your kids and for you guys, for the parents. So you can see your kids, that your kids are happy, that they're doing well. That's really kind of what it's all about in the end is you're really starting a new life. It's a new chapter in your life. And you have to write that chapter appropriately for what works for you. There's no one size fits all in a divorce. It's very specific to the individual. That's why I've always kind of said, family law is a funny area of the law where it really almost shouldn't belong in the courthouse, but there's just nowhere else to put it.
Right.
In most lawsuits, you're just suing for money, right?
Right.
Hey, Jay, you stepped on my foot. You owe me $100,000.
Oh man, that's an expensive foot.
I just got my toes done. Kidding. But in family law, there's so many aspects that are just so personal to the individuals where what the judge decides there.
Right.
It's just so personal where you're dealing with, time sharing or custody. You're dealing with how, your family, the assets that you've acquired over sometimes 20, 30, 40. I've even had, people who've been married for 50 years get divorced. How are you going to divide that up? How are you going to divide the family photos, the photo albums?
Yeah.
There's so many little aspects to it where judges really don't want to have to deal with that. And that's where a good attorney can really make a difference, is kind of advising you and coaching you on things that are worth fighting for in court and other things that you need to kind of work out on your own outside of court or through another means, essentially.
Right.
Because I've had people who've, I think we've all kind of seen the image on the internet of the people in the courtroom dividing up their beanie babies. That was kind of a meme that was going on.
Yeah.
I mean, I've done that with collectibles before. We've had to do that where we had to, get a big conference room. It wasn't in the courtroom, but it was a big conference room. And we brought these collections in and we had to value them and divide them up and all this kind of stuff. I mean, it can get crazy. And so you really want to make sure what you're doing is worthwhile. It's worth fighting for. Sometimes people will spend more on attorney's fees fighting over an item that they could just buy new instead of paying their attorney.
Because it's the principle of the thing I want.
Right. Principle will cost you money.
Right.
That's what I always say.
Very good.
So.
Well, listen, if it is something that maybe you are considering and you do need some legal advice when it comes to a divorce, you know that you can call for legal advice, the office, anytime at 1-800-DeWitt-Law. That's 1-800-DEWITT-LAW. And if you've got a question, maybe it's about divorce, family law, whatever the case may be, Mo's here to help you out with some advice. You can send your question and email it to ask@dewittlaw.com. That's ask@dewittlaw.com. And Mo, if they want to leave a voicemail, how do they go about doing that?
Just give us a call, 407-536-6737. That's 407-53 Moses. And, just leave a voicemail. Nobody's going to answer the phone. Just give us a call, leave a voicemail. People seem to like the emails better, but we like hearing your voice. So give us a call.
Absolutely. All right. We got more of your questions coming up in just a few minutes. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm, and we're taking your questions today. You can simply email them to us at ask@dewittlaw.com. That's ask@dewittlaw.com, or by calling 407-53 Moses. You can leave a voicemail right there. We'll just play your voicemail, and then Mo will give you some advice. And just remember, if you do need legal advice outside of the show or anytime, you can call the office here at 1-800-DeWitt-LAW. All right, Mo, let's get to one of our listener emails here. They said, I was driving down the road. I hit a pothole, which caused the wall of 2 of my tires to blow out and needs to be replaced. Is there something that I can do? For example, if the city officials knew or have known about the unfilled pothole in the past, can they be found liable for it, or is this on me?
So if they were on notice of the issue and they had a reasonable time to fix it and they did not, then there's a possibility that they could be liable for the cost of the tires.
How do you prove that?
It can be difficult, right? So that's why most people just say, I'm just going to go pay to get the tires fixed.
Yeah.
And hopefully they fill in the pothole. So yeah, you'd have to show basically that somebody else, sent them a letter, provided them notice. Now, in Florida, with our broad public records laws, basically you can typically get that information fairly easily just by doing a public records request saying, hey, have you received any complaints or repair requests for this area of road here?
Mm-hmm.
And, when do they come in, and look at it from there. Now, it all depends if this is worth your time or not to dig through this.
How mad are you?
How mad are you? Exactly. Obviously, if it's been there for a really long time and a lot of people have damaged their tires or damaged their vehicles on it, then, it may really become an issue where, hey, the only way to get the city's attention is to file a lawsuit to get them to fix this thing so we stop all breaking our cars, essentially. But most likely, if the pothole just developed and they fixed it within a reasonable period of time, then you're just kind of on the hook for the cost of your tires yourself, and that's just one of the hazards of driving out there.
Here's some bad advice. I saw this guy.
That's what you came to the show for.
I saw this guy do this, and it ended up going viral. Now, whether he took it down immediately or not, but he sent complaints over and over, and this wasn't anywhere in Florida, but he sent complaints over and over about this huge pothole in his street where he lived, and he finally got sick and tired of it, and he went out and he bought this little palm, like a little tree, and he planted it in it, and it was now right in the middle of the road. And the neighbors, of course, all loved it, and people went around it. But man, I can imagine somebody now hitting that, and then they go after that guy. Not a great idea.
Right.
Funny, but not a good idea.
Yeah, I mean, that's always where my head goes. Is somebody's, going down the road, doesn't know it's there. It's night. They slam into it.
Right.
Now they're injured. They're suing you. And
what wasn't there yesterday, and now it's there today. Now that guy's in big old trouble just trying to get a good laugh and going viral.
Yep, and could even, if someone's really injured, could even face criminal charges, frankly.
Oh, wow. On top.
So yeah, I mean, not the greatest idea. Hopefully he took it down after the viral video.
That's what I'm thinking. Maybe he just planted it, took a picture, hit post, and then immediately went and ripped it out.
Yeah, I mean, I did have an attorney friend in a different state who they started a campaign where, I forget if it was an app or that you would just email them, but to have people report potholes, and then they would report them to the city. And they thought it was going to piss the city off, but the city actually loved it because they're like, oh, we want to fix these things. We just need to know where they are.
Right.
So they got their crews out there fixing all the potholes, and the city was happy. And
look at that.
Yeah. So they,
it backfired in a good way.
Yeah, backfired in a good way. Exactly.
Oh, I love it. All right. So listen, if people need some advice from you, tomorrow, during business hours or even after business hours, what's the starting point? What's the best thing for them to do?
So just give the office a call, 1-800-DeWitt-LAW, 1-800-339-4885. There are people there 24 hours a day. Remember, those people obviously aren't attorneys, but they can set you up for a time for us to talk. If you do have a simple question, you can always email us, ask@dewittlaw.com. But the first step is always just giving us a call. setting up that consultation so that we can sit down either over the phone, on Zoom, in person, whatever you prefer, and talk through the situation, see what's going on, and kind of guide you in the right direction from there. And it may be a situation where it's not something we handle, and we'll put you in touch with somebody that we trust to handle that for us, if we know somebody. Because we don't do every area of law. I know on the show we kind of talk about all sorts of stuff. But if it's something we can handle, we'll certainly sit down and do a consultation with you. If it's not, then we'll point you in the right direction and get you into some good hands.
Perfect. And some more of that advice coming up from your emails that you've sent in to ask@DeWittLaw.com. We'll be back in just a few minutes. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
So I want to show you something. Here, come closer. See this letter here? This letter offered for our client to settle for $10,000 back in May of 2021. We just got this client $200,000 for that same accident. He didn't want to take the $10,000, and rightfully so, because the insurance company was offering him pennies on the dollar. Oftentimes, clients get impatient, but in this case, it was worth the wait and worth to fight the insurance company to get what he deserved. Injured on the go? Just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with Mo DeWitt of the DeWitt Law Firm every Sunday morning right here at 10 a.m. That's how you'll learn Florida's legal issues and how they affect you with your host, Mo DeWitt. Mo's answering your questions to discuss the latest legal issues affecting the citizens of Central Florida. And speaking of one of those issues affecting Central Florida, let's talk about the hurricane and flooding. Got this one here, Mo. They need your advice. Mo, I'm having an issue with homeowners insurance, and hopefully you can help us out. During the hurricane, our backyard flooded high enough to cause tons of erosion. It also came into our back room. We've got video of it as it was happening, and we even tried diverting the water as much as we could. Biggest concern, not knowing if there is possible foundation damage because of how big the hole in our backyard is, and it's up against the foundation. Said we made a claim, and the adjuster came out and took pictures and all. We just got a call from the insurance saying the claim was denied because there is, quote unquote, no damage from a flood to our house. So we're planning to start filling the hole before we get more rain and it gets worse, but obviously coming out of pocket at this point. Is there anything we can do to fight the insurance on this?
So the first thing you want to do is document everything. So you want to take pictures, videos, show all the damage that's there. Obviously, you have an obligation to mitigate the damage as well. So you may have to come out of pocket to fix some of this stuff so it doesn't get worse, right? But I would go ahead and document all that damage and then resubmit it to the insurance company and start there. If they still deny the claim, then that may be where you need to get an attorney involved. And if you need somebody, call the office and we'll put you in touch with somebody. This isn't something that we do in the office here.
Right.
But those are kind of the steps. Is mainly you want to document everything. You also want to keep all your receipts. So anything that you're paying for out of pocket that's costing you money, you want to make sure you're keeping those receipts, because at the end of the day, it's going to be fixed. So the insurance company is going to say, okay, we let's assume we agree with you that you have a claim and that we have to pay for it. How much do we have to pay? And believe it or not, the insurance company just doesn't take your word for it. I've actually
imagine that.
I've had to have this conversation with clients before, where they'll send me a spreadsheet of what their damages are. And I go, well, that's great, but where are the receipts? Where is the proof? You have to have proof, right?
Yeah.
If you go to court, you have to have proof. If you're dealing with the insurance adjuster, they want to see proof. Either way, you gotta prove your claim. So keep all those receipts, keep them in a safe place, keep them organized, and document everything. And so then it's just going to be about whether we'd have to look at why it was denied in more detail. At that point, they say, okay, there is damage here and we're going to cover it. Then hopefully they'll pay it. If they deny it for another reason, or say they're not going to pay for all of it, or not going to give you fair compensation for it, then it may be time to contact an attorney and discuss your options with them.
Same thing with like a roof. If you've got a leak, you got to make sure you blue tarp it to avoid more damage from coming in, that type of thing.
Exactly. Yeah. You can't just leave it open and let it destroy your entire house and say, hey, guess what, insurance company?
You denied me, so I'll show you.
Right. Exactly.
Not a
It
good
doesn't
idea.
work that way. Now, I mean, obviously sometimes we've seen cases before where, a tree falls on a roof, and even though they get it tarp, there's still water getting in there, and
Sure.
ultimately the whole house has to be gutted and renovated. That does happen, and then the insurance company should be covering that as well. But yeah, you're supposed to try to take whatever steps you can, precautionary steps, to help mitigate that damage.
Makes sense. Plus, you don't want your stuff getting ruined anyway.
No, of
Save what you
course.
can.
Yeah.
So, all right. Here's one regarding a car accident, an email that we got to ask@dewittlaw.com. It says, Mo, I was recently involved in an accident and I've been handling the claim myself. The insurance company is asking me to give a statement. They want to record it. I've been trying to be cooperative and they've been very nice, but I'm a bit uncomfortable about giving a recorded statement. Do you have any advice on this? Do I have to give them a recorded statement?
So it depends whether it's your insurance company or the other insurance company as to whether you're required to give them a recorded statement. So,
Okay.
first of all, I would highly recommend not handling the claim yourself. There has been research done, and there was a research done actually by the insurance companies, and their own investigation showed that people who handle claims on their own versus ones who have an attorney, the people with an attorney get about 3 times more, a little over 3 times more in value. So I would discourage that. But to answer the specific question, with your own insurance company, you have a contract, and part of that contract is cooperating with the claim. So if they want you to give a recorded statement, you do have to give a recorded statement.
Okay.
You can schedule that. You don't have to do it right then. You can have an attorney present with you if you'd like to do so. If it's the at fault party or the other party's insurance company who's asking you to give a recorded statement, you owe them nothing. You have no obligation to do that. There's not been a lawsuit filed at this point that obligates you to sit for a deposition. And so there's no reason for you to give them a recorded statement. Typically what they're doing here is they usually try to get you about 24 to 48 hours after the accident.
Mm-hmm.
And they want you to give a recorded statement to see what your injuries are. The problem is at that point in time, unless it's a catastrophic accident, you may not fully know what your injuries are. You may say, oh, my back hurts a little bit, my neck hurts a little bit. But anyone who's been in a car accident knows kind of like day 2, day 3, that's when things really start getting sore. You start feeling it, the adrenaline subsiding. So they kind of want you to say stuff like, oh, I'm fine, I'm feeling okay, I'm a little sore, I'm a little achy. And then later on, if you had a herniated disc or something like that, they're going to say, well, when we interviewed you the day after the accident, you said you were just a little sore. Now you have all these other problems that this clearly wasn't related to the car accident. So they're going to try to do stuff like that. So again, there's no obligation to give them a recorded statement. You're better off, in my opinion, not doing it unless you're contractually obligated, like with your own insurance company. Then you do need to give them the statement.
What if they say something like, well, we have to process this to move forward?
Well, they're lying, frankly.
Okay.
I mean,
Say,
they
no, you
don't. Yeah,
Okay.
they don't. And most insurance adjusters that I've dealt with, 95% of them probably are good people who I don't think would lie like that. I'm sure there's some shady ones out there too.
Sure.
Just like in any profession. But usually they'll ask you, are you willing to give a recorded statement? And the funny thing is people want to be helpful, right? Typically people want to be helpful. They want to cooperate. So I think a lot of times they just agree because they're trying to be helpful, right? You have nothing to hide. You weren't at fault. You were in this car accident. You just want to make sure that you get, fair compensation from it, get your medical bills covered, make sure, any lost wages are covered if you're out or in the hospital or whatever it is, and get your car fixed. I mean, that's what most people want.
And just move on quickly.
And just move
You're
on.
Right. Yeah.
But the problem is, I always say if it was that easy, there wouldn't be all these injury attorneys in town. You wouldn't see billboards and commercials because, hey, if the insurance companies were paying fair compensation, there'd be nothing for the attorneys to do, frankly.
Right.
So, that is part of their job, is to basically gather this information, and then ultimately they're going to protect their own insured, their own insurance company, and try to pay as little as possible on the claim. That's just what they do. Whether you agree with me or not, I've seen it 1,000 times.
What if you have a minor? What if your kid's like 16 and they're driving a car and somebody crashes into them and it wasn't your child's fault and they want to do a recorded statement with your kid? Do you tell them that's fine as long as I'm on the phone with them, or best to contact an attorney? I mean, if it's not a severe accident.
Well, same thing would apply. So again, I would always recommend, if it's the other side's insurance company, not to give any sort of statement to them. If it's your own insurance company, usually they'll have the parent or guardian on the phone while they do the recorded statement.
Gotcha. All right. Let's get to our next question. Having a problem with our landlord. Says, we live on the West Coast and recently moved from one rental property to another to escape this horrible landlord. It's been 30 days since we moved out. We finally got a certified letter regarding our security deposit. Says, on top of keeping the full deposit, which was just over $1,000, he's claiming an additional $1,500 in damages. Says that he sent us an itemized list of damages, which includes some repairs he made during our tenancy. For example, at one point over 6 months ago, the shower handle broke off when I went to take a shower before work. At the time, he claimed I used excessive force to break it on purpose. This lady must be really
hard showers.
Right.
Yeah.
And he tried to charge us or even just split the $800 repair with us. And my husband argued they finally paid in full, but now they're trying to get that money back. So in short, my question is, can they charge us for repairs made during our tenancy?
So a couple things to look at here. First of all, with security deposits in Florida, there's a very specific time frame as far as when they have to be returned. So I don't have the statute in front of me, but if you look up the statute, basically, once you move out, I think they have 30 days to return the security deposit or make a claim for damages, essentially. Send you a letter saying, hey, we're making this claim on the security deposit.
Which is what it sounds like this guy did.
Right.
Okay.
But if he's not within that time frame, he waives all right to make a claim. So
I gotcha.
First check to see if he is within the time frame to make the claim. If he is, then you want to look at what he's actually claiming, right? So again, just like we talked about before, ask for receipts, right? He has to prove his claim. You can't just send you a spreadsheet and say this is what it costs. Ask for the receipts and then invoices from the actual vendors. Now, there's also a difference, and it's going to depend on what your lease says, but usually there's a difference between damage and normal wear and tear.
Okay.
So if the shower handle thing broke, it sounds like that's more of a normal wear and tear, unless you did just rip it off.
Right.
That's more
Took
of a factual
to it. Yeah.
But those things are more normal wear and tear rather than actual damage. Again, you have to go back and look at the lease to see if you're liable for normal wear and tear or not. But security deposits are really supposed to cover damage in their true form. It's damage to the property. Now, hopefully when you moved out, you took pictures of everything, videos of everything, and documented everything.
Mm-hmm.
Even down to, hey, I cleaned the oven, I cleaned the microwave, because I've had people be hit $100 cleaning fee to clean the oven out, $100 cleaning fee to clean the microwave out. It's a little ridiculous, but sometimes
nickel and dime them.
You're gonna get nickel and dime. So you want to make sure you document all that. And then if he's going back throughout the course of the tenancy and say, hey, I had to repair this or I had to repair that, a lot of times that stuff's going to be more normal wear and tear rather than actual damage. Now, he is arguing, obviously, it's damage because he's saying you used the shower handle too hard. I don't know if it went to actual court, if the judge would buy that, especially if it's during your tenancy. There was no ill will at that point to try to break stuff, right?
Yeah.
It's not like you're moving out. And sometimes people try to trash the property or something. Obviously, that wasn't the case.
And plus, this guy kind of backed down, it sounds like, eventually, and just the landlord just went ahead and paid it all in full at some point. But now you're coming back 6 months later going, hey, no, I want that money back.
Yeah, so it's probably worth arguing, saying, hey, you already agreed to pay for this.
Right.
You already agreed we didn't break it. It was normal wear and tear, and that we shouldn't be liable for it. But anything, most things when it comes to, tenancies like this are going to boil down to what's in your lease and what's covered. That's why you want to make sure you read through that lease before you sign it, see what you're responsible for, see what you're liable for. A lot of times there's a cleaning fee when you move out, or if you had pets, there's pet fees and things like that. Obviously, it seems like this is a bad landlord, so that's why you got away. And this is kind of the last part to deal with them. But if you can't work it out, ultimately you could end up in small claims court over it. You could make a claim against him. He could make a claim against you. And you just have to determine if that's worthwhile doing or not, depending how much is at stake.
How many times have you said, whether it's a car accident or just moving out, how important are everybody's got their phone in their hands 24/7. How important is it just to take a couple pictures and take a little bit of video, whether it's before and after Hurricane Ian, getting into a fender bender, moving out of a rental property? I mean, it takes 60 seconds, but it could make the difference in any kind of he said, she said.
Absolutely. I remember there was an attorney in town a long time ago who used to run a commercial saying to keep a disposable camera in your glove box
Mm-hmm.
for if you ever got in an accident. And now we all have cameras in our pockets all the time.
Right.
And people just don't think about it. So
Right.
that's why I try to hammer into people's heads, if you're in an accident, take pictures of everything. You may think it sounds silly, you may think it's nothing, but I've seen a million horror stories before, that we could spend hours discussing.
Right.
Where photos, videos, they just help a lot to avoid that.
Absolutely. Yep. It gets rid of all that he said, she said
Yep.
business. You are listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. If you've got one of those questions, you're like, ooh, I need to ask Mo something. No problem. You can email it to us, ask@dewittlaw.com. It's spelled DEWITT. Again, ask@dewittlaw.com. You can also call if it's easier. You just want to explain it real quick in a voicemail. We'll just play your voicemail, and then Mo will be able to answer your question for you and give you that advice. You can leave your voicemail at 407-53-MOSES, 407-53-MOSES. And just know that if you need legal advice at any time, you can always call the office. That number is 1-800-DeWitt-LAW. That's 1-800-DEWITT-LAW. We've got our Mo Pro Tip of the Week coming up in just a few minutes. We'll be right back. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Someone ran a stop sign about 50 miles an hour and hit my truck basically head on, and it caused a lot of damage to the vehicle, but also hurt me as well. The insurance company reached out like, hey, we'll make this all go away if you just, sign this and take this money. And even though that was my first accident, I knew that wasn't the way it should have went, and that's when I decided to call Mo.
So after the accident, the insurance company approached Mark and tried to give him $1,000 to waive all rights to bring a claim. Fortunately, he was suspicious and knew better.
So it was no, if you have a question, just call me at my office or email me here. And I really enjoyed that.
Ultimately, in this case, we were able to recover $110,000 from Mark's injuries.
He's funny, he's approachable, but he also knows what he's doing. And if I knew anyone who's injured and needed a lawyer, I would definitely recommend DeWitt Law Firm. If you're injured on the go, just call Mo.
Mark's a great guy, and I'm so happy that we were able to help him with his accident case.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm. Send those questions to ask@dewittlaw.com. You can call 407-53-MOSES. Leave a voicemail there so Mo can get to your question and provide you with some advice, answering your questions, discussing the latest legal issues affecting the citizens of Central Florida. All right, Mo, got time for one more here before we get to our Mo Pro Tip of the Week. Says, considering going through a divorce, my husband makes more money, almost nearly all the money when it comes to the house. Am I able to recoup any type of lawyer's fees since he's primarily the person bringing in most of the money in the house?
Yeah, so I mean that's something that we deal with a lot, honestly. Attorney's fees in a divorce are the same standard as alimony, so it's based on need and ability to pay. Mm-hmm. Does one party have a need for them to contribute to their attorney's fees, and does the other side have the ability to pay those attorney's fees? Where we see people get tripped up a lot of times, though, is typically when you hire an attorney for a divorce, even though you may be able to recover attorney's fees down the road, you still have to usually pay the retainer up front with that attorney. So that's something you're going to want to plan for, whether it's putting it on a credit card or budgeting for it, kind of as your pre-divorce planning. That's something you're going to want to have in mind is, how am I going to pay that retainer fee?
Okay.
Now, as the divorce goes on, if you need more money, your attorney may be able to file what we call a motion for temporary attorney's fees, where they can ask the other side to contribute to attorney's fees during the pendency of the case. At the end of the case, you can also request that you get reimbursed for attorney's fees. So there are a number of ways to deal with attorney's fees kind of once you're in the case or at the end of the case. But typically, most people have the most difficulty at the beginning of the case. They're figuring out how to pay the attorney. So, when you're if you're contemplating divorce, that's one of the things you want to think about is, okay, how do I pay my attorney,
Mm-hmm.
right? So it could be fairly expensive depending on the case. So whether there's a credit card available, whether you have money in a separate account available, Obviously, as part of the divorce, you're going to disclose how you paid it or wherever you paid it from. Maybe friends or family members are going to loan you the money. So those are just kind of things that you want to plan out as part of the divorce process. So you're not kind of blindsided of, hey, I moved out of the house. I need to hire an attorney. I don't have any money because I just paid all my money on, security deposit or rent or whatever it may be. So just something to keep in mind. But again, yes, to answer the question, you can be reimbursed for your attorney's fees. It is the same standard as alimony, need and ability to pay. So you have to show first that you have the need for the other side to contribute to your attorney's fees. And second, that the other side has the ability to pay, the present financial ability to pay to contribute to those attorney's fees. Usually that's going to mean a much higher ongoing income or, cash reserves of some kind that you can access.
Gotcha. All right. Good.
Yeah.
All right. How about our Mo Pro tip of the week? What do you have this week for us?
So, I always say it's not what you know, it's what you can prove. And so as we've been talking about throughout the show today, any time that you're going to court or bringing any sort of claim, you have to prove it in a court of law. And so many times people come in and say, oh, I know this happened. I know that happened. Well, we have to prove it. If we're going to go in front of a judge, we have to prove that with evidence and witnesses, and be able to show that. It can't be hearsay. People know what hearsay is. So, whenever you're dealing with any sort of claim, whether it's a divorce, whether it's a roofing claim, whether it's, property damage, you want to get the documentation together. For a divorce, it would be, getting your pay stubs together, your bank accounts together, your mortgages together, the deed to the properties, all the kind of documentation for all the assets. If it's a property issue, a property dispute, and there's damages that have been incurred, or if you're fighting with your landlord over repairs they made, again, you need receipts, you need evidence. So you want to make sure that you're kind of thinking in that mindset before you ever get to court, even before you start talking to an attorney, because the first thing they're going to ask you for is, hey, this is the information that I need to gather. So if you're a step ahead of that already, it will make your life easier and the case will go faster. And it'll probably be a little bit less of a headache and probably a little less expensive too.
Having your ducks in a row.
Absolutely.
There you go. That's our Mo Pro tip of the week. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. If we didn't get to your question today, don't worry. We will get to it. And if you have one for yourself that you'd like to go ahead and submit after listening today, send your question in to ask@dewittlaw.com or leave that voicemail 407-53-MOSES, and we'll get to your question. And also for legal advice, call the office anytime right here at DeWitt Law. That number is 1-800-DeWitt Law. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk.